Okay, this is the 140-160 requirements class. This is Monday of week 2, which is April 10th. And we're going to begin with some city, states, and zip practice. Everybody ready? For the record, Montgomery, Alabama, 36134. Juneau, Alaska, 99801. Denver, Colorado, 80213. Washington, D.C., 20001. Honolulu, Hawaii, 96811. Indianapolis, Indiana, 46249. Frankfort, Kentucky, 40601. Boston, Massachusetts, 02154. Jackson, Mississippi, 39223. Lincoln, Nebraska, 68502. Concord, New Hampshire, 03301. Raleigh, North Carolina, 27633. Bismarck, North Dakota, 58501. Providence, Rhode Island, 02903. Austin, Texas, 78722. Olympia, Washington, 98501. Victoria, British Columbia. Winnipeg, Manitoba, R3M2Y6. Cheyenne, Wyoming, 82001. Phoenix, Arizona, 85018. Hartford, Connecticut, 06132. Tallahassee, Florida, 32301. Boise, Idaho, 83762. Des Moines, Iowa, 50336. Baton Rouge, Louisiana, 70858. Lansing, Michigan, 48931. Jefferson City, Missouri, 65101. Carson City, Nevada, 88701. Santa Fe, New Mexico, 87501. Harrisburg, Pennsylvania, 17104. Columbia, South Carolina, 29233. Salt Lake City, Utah, 84103. Charleston, West Virginia, 25341. St. John's, Newfoundland. Quebec City, Quebec, QR3 7U8. Little Rock, Arkansas, 72254. Sacramento, California, 95877. Dover, Delaware, 19901. Atlanta, Georgia, 30358. Springfield, Illinois, 62790. Topeka, Kansas, 66621. Annapolis, Maryland, 21421. St. Paul, Minnesota, 55132. Helena, Montana, 59601. Trenton, New Jersey, 08651. Albany, New York, 12202. Columbus, Ohio, 43223. Salem, Oregon, 97341. Pierre, South Dakota, 57501. Richmond, Virginia, 23297. Madison, Wisconsin, 53703. Halifax, Nova Scotia, Regina, Saskatchewan. Okay, some medical terms for practice for the record. Umbilical, hepatitis, coccyx, epilepsy, hysterectomy, examination, insomnia, radiology, lateral, pressure, deceased, extremities, swelling, posterior, ischemia, erythrocyte, endocardial, hypodermic, Alzheimer's, proctologist, podiatrist, hemorrhage, laminectomy, dizziness, clinical, orthodontics, angiogram, leukocyte, diseased, obstetrician, gushing, intravenous, hydrotherapy, myopathy, laparoscopy, retrograde, visceral, vaginal, chiropractic, atrophy, melanoma, radiologist, spurt, headache, anterior, atrophic, obstetrics, vessel, fever, spinal, onychomycosis, acromegaly, hysterectomy, renal, gastric, testosterone, dyspnea, aneurysm, prescribes, injury, symptomatology, fracture, plantar, cardiac, myelogram, vertebral, dorsal, tumor, pathology, thoracic, cranium, amniocentesis, appendicitis, clavicular, acoustic, metabolism, bleeding, musculature, cerebral, subluxation, death, brain, transverse, broken, dentist, cystocele, melanoma, nephropexy, mastectomy, and colostomy. All right, this is some congressional record practice for the record. Mr. Gable, ladies and gentlemen in this chamber, and Mr. President, I want to thank the senator from Iowa for his insightful comments. I agree 100% with his point of view. We are facing many problems in this country, and this issue is one that should be addressed immediately. It is timely and on the conscience of many Americans. One of the greatest losses to our economy and to the nation as a whole is that women have not been able to take a more active role in the daily affairs of the business of America. Their input would be an invaluable asset to the corporations and businesses of America. Their expertise and experience needs to be tapped. In my research over the last few months, I have found that many of our nation's most respected periodicals have been conducting in-depth studies and surveys to determine the number of women who are involved in the day-to-day management of corporate America. How many women are involved on a daily basis in business affairs that affect the economy? Business Week magazine recently conducted a survey of over 10,000 women who are currently involved in management in corporate America. There were approximately 5,000 responses to the questionnaire from women across the country. From the responses received from the survey, out of a total of 5,000 top-paid, higher echelon individuals involved in corporations and businesses in the United States, 22 of those positions were held by women. Of those 22 women, 15 were in positions of responsibility because of family circumstances. 8 of the women were married or had been married to the chairman of the board or the main stockholder of a major corporation. 7 of the women had inherited the position from another family member who was deceased. Another 7 of this total had actually worked their way up through the ranks of the corporation to an executive position or a position on the board of directors of a major corporation through diligence and dedication. From these statistics, we realize that female representation in corporate America is sadly remiss. What we need to ask ourselves is how this situation came to exist. We need to ask many questions. Is this a gender issue? Is this a man-made issue? Is this the natural order of things? How did this situation come to pass? Have women been given an equal chance to succeed in corporate America? Do they want to succeed in corporate America? Is the male-dominated scene in today's business world a situation that exists because women are just not interested in becoming leaders in big business? Have women ever been given the chance to succeed in corporate America? Until radical changes in the last 20 years, some of the better colleges and schools in the United States of America were classified as men-only institutions. This belief is nothing short of ridiculous. It fosters the old school of thought that women belong at home behind the stove, cooking, cleaning, and caring for the family. Women excel in areas where men fall short. It has been proven that women are as intelligent as their male counterparts. They should be given a chance to climb the corporate ladder. They should be given equal chance to compete in today's world of business. We should not only encourage women to seek an equal chance, we should enable them to get that chance. As the representatives of the people, it is our duty to ensure that women receive the same opportunities as men. We must afford women the same career paths that are available to their male counterparts. Women are beginning to get into the top law and medical schools. In some regions of the country, women students make up over 50% of the student population. The doors are opening for women, but it is a slow process. We as members of Congress should do our utmost to encourage student loans and grants for women. We should discourage any legislation that does not promote gender equity. As members of the House, we should work towards social and economic equality for the sexes. The problem this chamber is faced with is quite a perplexing one. Paul Lang Taylor, who has been a member of this House for 10 years, has adapted a posture of defense to support the right for the continuation of all male social clubs that exclude women. His position is contrary to many of the beliefs and policies that he has advocated for anti-discrimination in all walks of life. By taking this stance, Paul Taylor is promoting the concept of exclusivity. I wonder if Mr. Taylor perceives the real issue here. Discrimination is involved in this issue. A social club is organized for many reasons. Some are organized to conduct business. Some social clubs are organized to promote the interests of the community. Some social clubs are organized for charitable work. Others are organized for the fun and enjoyment of their members. If women are excluded from any of these groups, Mr. Taylor is inferring that they have no business conducting these activities side by side with their male counterparts. I do not agree with Mr. Taylor's viewpoint. I would like for him to present to this committee within the next 30 days a written justification of his position. Ladies and gentlemen, this issue has been discussed by various committees, including ours, and we are in favor of censuring Mr. Taylor from this chamber until this matter has been resolved. Mr. President, we request at this time that this issue be dealt with in the most expedient fashion. Okay, this is some jury charge material for the record. Ladies and gentlemen of the jury, this indictment now embraces those offenses of assault and battery of a very high and aggravated nature. Obviously, if you conclude the state satisfied you of any offense in this category, then the defendant party, these alternative offenses again, the defendant party could only be found guilty of one offense within this category, either the principal offense of rape or the lesser included of assault with intent to ravish, or the third lesser included of assault of a high and aggravated nature. First, then, defining the offense of rape. The legislature of the state has enacted a statute which basically simply restated the common law, our traditional law, on the subject in this language. Whoever shall ravish a woman when she did not consent, either before or after, or ravish a woman with force, shall be deemed guilty of rape. The word ravish, the word rape, as used in the statute, are synonymous terms. Both describe the same offense, and that offense is the unlawful taking of carnal knowledge of a woman forcibly and without her consent. The words carnal knowledge mean the same thing as sexual intercourse. Consequently, the offense of rape is the accomplishment unlawfully, that is, without lawful right or authority, and this would occur if the other elements of the offense are made out, the elements of force and absence of consent. Rape, then, is the unlawful accomplishment of sexual intercourse, male against female, forcibly and without the consent of the female. Now, there obviously cannot be carnal knowledge unless there is a penetration of the male organ into the female organ. Proof of any penetration, however slight, would be sufficient to make out this element of the offense. Carnal knowledge is accomplished by penetration. The state does not have to prove as an element of the offense any emission of semen. There must, however, be an actual penetration to some extent of the male organ into the sexual or genital female organ, but penetration, however slight, would be sufficient. Now then, the further elements, if such act of sexual intercourse or having of carnal knowledge be shown to exist, the further elements then to make out the offense are the following. that such act of carnal knowledge or sexual intercourse was accomplished by force and without the consent of the female against her will. In order then to constitute rape, the carnal knowledge must have been accomplished by force on the part of the male, sufficient to overcome resistance offered by the female. Mere protestation on the part of the female would be insufficient. Proof of actual resistance is sufficient to a conviction of the offense unless it be shown that a female was either incapable by reason of some present physical condition of resisting, or unless it be shown that she yielded herself through reasonable apprehension of imminent and serious bodily harm induced by threat or threats or show of force on the part of the male. The importance, then, of resistance by the female person is to show the use of force by the male and the element of non-consent on the part of the female. The sufficiency of resistance offered must, of course, be judged in the light of the surrounding circumstances, as you find those to be, such as the relative strength and position of the parties, age, physical conditions, and what you find to be any degree of force to have been manifested or used in the way of threat of exertion of force by the male person. In the law, a female need not resist until her strength or consciousness is gone. The requirement of resistance by her would be satisfied when her conduct has been such as to make her non-consent and her actual resistance manifest, or her status being that of being overcome by threat or show of force on the part of the male. Summarizing then, the offense of rape consists basically of three elements, three things of fact. First, the occurrence of the act of carnal knowledge, act of sexual intercourse. Secondly, that force was used by the defendant to accomplish that purpose. And third, that this was done without the consent and over the resistance of the female, or that her resistance was overcome by reasonable apprehension of serious bodily harm induced by threat or show of force on the part of the male. In order then for the state to be entitled to a verdict of guilty of that offense, you must conclude and be satisfied beyond reasonable doubt that the defendant party was present and that he did commit that offense as defined to you by the accomplishment of sexual intercourse, the having of carnal knowledge of the female by the use of force and over her consent, that is, without her consent. Further commenting on the element then of force in the commission of the offense, the law refers by this element to such force as is sufficient to overcome the resistance of the female person. The required force then is that by which a dissenting female is subjected to and put under the power of the male, so that he is able, notwithstanding her lack of consent or opposition, to have sexual intercourse with her. Such force in the law may be either actual occurrence of physical violence or constructive force, the degree of force and the degree of resistance being elements to be found by you from your judgment of the circumstances of the case, but it again being necessary that you find beyond reasonable doubt that there did occur the act of sexual intercourse, that such was committed with the use of force by the defendant to accomplish that purpose, and that that was done without consent of the female person, and either over her resistance or that any resistance was overcome by reasonable apprehension of serious bodily harm or by show of force on the part of the male. Okay, this is some more legal material. It's on implied malice for the record. Now, I want you, ladies and gentlemen of the jury, to consider what I have done so far. Consider everything that I have talked about so far with the evidence. The evidence proves each and every element of this case as charged. But I'm going to talk now just about the facts that I don't think we discussed as yet, that have proven that Mr. Farrell acted with implied malice. The facts will reveal that he acted with implied malice. Remember that there was a limiting instruction on that. The judge said that when we started talking about the arrest in Blythe, it wasn't to try to make you think that Mr. Farrell was a bad guy just because he has been out drinking and driving before. No, that is not the case. Ladies and gentlemen of the jury, remember that implied malice is a specific mental state without which Mr. Farrell cannot be convicted of murder. It is a specific mental state that you have to believe that he had. So we know that at about 4 in the afternoon on Saturday, July 24th, he was picked up by Roger Whittier of the Blythe Police Department. Roger Whittier sent out a reported call. He found Mr. Farrell in his red or burgundy Nissan weaving down the road. We know he was arrested for driving under the influence. They found him to be more than double the legal limit driving an automobile in the state of California. His blood alcohol content was measured twice through his breath. Well, ask yourself, why twice? How do they arrive at twice the limit? Because that's the law in the state of California. They use a machine that has been calibrated. He was at 0.19 or 0.20. Obviously, 0.19 or 0.20 is more than 0.08. Some of you may wonder how he was even functioning at that level of intoxication. That's a good question. We know, in addition to everything else, that Roger Whittier could tell he was under the influence because the symptoms he exhibited, slurred speech, red eyes. He failed the test. No, Mr. Whittier, he said. Mr. Whittier, you got me. You caught me red-handed. I knew better, and I knew it was wrong. Officer Whittier said he tried to act contrite. Okay, I think that is real important about the knowledge he had. Even then, he said, I knew I was wrong. I should not have been driving. Why did he make those statements if he thought he was in the right? He knew he was in the wrong at that time. 5.5 hours later, we know that he is released. We know that he no longer gets released. And then what does he do? He goes out and finds the nearest liquor store. He goes into the liquor store. Mr. Hoover testified that he sold the man a fifth of vodka. We know that the defendant was back the next morning. He was back at the same liquor store. We heard Mr. Kegel testify that he was there to cash a check because he wanted to get his car out of storage. We know that between the hours of noon and 2, he showed up at the Colorado Bell Casino. Will Jessup was the bartender. It was Will Jessup's birthday. Happy hour was just starting, and there were a lot of customers in the bar at the time. And at that fairly early hour in the day, Mr. Farrell came in, and Mr. Farrell was obviously intoxicated, very drunk, according to the testimony of Will Jessup. We know that he was drunk enough that when Mr. Farrell ordered a beer, Mr. Jessup turned him down. We also know that when Mr. Farrell was in there trying to buy a beer, Mr. Jessup asked Mr. Farrell, "Are you driving?" What did Mr. Farrell say? He said yes. Mr. Jessup asked Mr. Farrell, "Can I get you a taxi?" And as we all know now, he refused that offer of a taxi. He just walked out of there and refused it. And at that time, one of the first of many times, he turned his back on an opportunity to save himself, to save the life of Louise Hastor. He walked away from the only chance he had to save another life. He said no, and he left. We know that Mr. Farrell went and picked up his car out of storage from Lane Paul. He paid $104 in cash, which was the towing fee. We know that Mr. Paul could tell Mr. Farrell was intoxicated at the time he picked up the car. Mr. Paul asked him if he had been drinking.